Hello, everybody, and welcome to the July 2021 Wisconsin Water Well Association Government Relations Update. My name again is Jeff Byringer. I'm the Government Relations Advisor for the group, and hope you are enjoying these monthly updates in video format. Give you a quick insight into some of the issues that we're looking at on behalf of you all as members of the organization. So let's start this month with another quick update on what's happening with the NRA 12 rule package. This specifically is dealing with the one with the expansion or the consideration for the use of PVC into consolidated formations. At this point, the economic impact hearing has been held. The association provided input into that. The agency will start coming out with responses on that. And after they've done that, they will then proceed to the next phase of the process, which is to have more specific insights into public comments on the text of the rule more so than how will it affect costs, whether they're higher or lower. So they've gone through the economic impact piece. Like I said, the public hearing part is next. Still a very, very long way to go in this process. The other rule that we're also keeping an eye on, the NR board this past month considered an emergency rule under NR 146, which deals with testing and licensing and such. In this particular case, the agency is asking to be allowed to use a third-party agency to do testing. Our comments regarding this, and it was only the economic impact piece that was being heard. But we let our testimony drift a little bit to speak to some of our concerns about third-party testing, specifically the concerns being making sure that the integrity of the test is maintained, that if we go to some form of online testing, which this contemplates, that we are not sacrificing quality in any way, and that there's no chance that the test ends up out on the streets and something that becomes a little bit easier to pass than what all of you probably did to pass your examination. So the agency is telling us that they're working with the vendor. They share our concern and are anticipating having a solution that all of the stakeholders can agree on. This particular testing refers to any of the testing being done by some of the DNR departments and such. So specifically it's well drillers and pump installers, but it also affects people at pump septage and a few of the other programs that they administer. All right, next up is NR 809. NR 809 are the standards for drinking water. Those are being reviewed. The board has taken a look at these and specifically circled the questions regarding PFOS and PFAS and exactly what's going to happen under these standards. You might recall that the EPA has not actually issued particular actionable standards for these chemicals, these forever chemicals, as they're called. So as the agency looks at adopting a drinking water standard, the question is going to be, well, what's the standard going to be for these chemicals if there is no federal standard? So if they create a state standard, is making sure that there's good science as to indicate why did we set an actionable level at that rate. So this is going to be a contentious rule going forward, particularly on this topic. Otherwise, we didn't have a lot of comment as directors looked at this, but certainly if any of you have comments about anything that's in the drinking water standards, we would appreciate hearing your comments. My contact information will come up at the end. Feel free to give us a call. One of the other issues that I wanted to talk about briefly was the state budget that has now been signed into law by Governor Evers. The budget includes changes to the well compensation fund, specifically additional funding for that fund. Doesn't really change much in terms of eligibility and such, but it does provide an additional $2 million in each of the fiscal years to $1 million in each of the fiscal years, $2 million total, to provide more grants to people who are looking to rehabilitate or replace a failing well. The budget also includes an additional staff person for the Department of Natural Resources and specifically the drinking and groundwater program. My understanding from conversations with the department is that this position will be an inspector's position, may have some other responsibilities as well. Incidentally, on staffing, we should soon be hearing more about a replacement. You might recall when Marty Nessman was put into the position of being the Bureau Director, his position became vacant, and we're getting closer to the time when that position will be filled. So that's not a new position, but we'll get a new person that we'll be working with. So we'll look for an announcement on that before too long. This other position that's created under the budget could take a while before it's actually filled, but nonetheless, the funding and the position authority is included in the budget. So that's good news for us. You're probably all aware that the budget contained tax cuts. It does not include the elimination of the personal property tax that was not included in the final deal. However, it does include both property tax reductions and also includes income tax reductions. I think some of the folks were surprised that the governor signed this bill and he immediately claimed credit for some of the work that was done. And in fact, if you sign the bill and don't veto it, he does deserve some of the credit for it. But I think most people understand that there was a vast difference between the governor's budget and the one signed by the legislature or passed by the legislature. And the two had very different approaches in terms of how they were going to make it to the bottom line and include all of their spending proposals. In the end, again, I think the governor has taken his due for this, but he also signed a budget that was passed by the Republican legislature. So if you're looking for any sort of symbolic bipartisanship on the part of the state, I think what you have here is a budget that neither party was thrilled with, but at the same time, a budget that did have both Democratic and Republican support, including some Democrats who voted for the budget when it came before the assembly. So that's the first time that that's happened in about 14 years. So maybe a little bit of shift, but more so, I think the ability to fashion a budget in an environment when there was probably more money available, and then some additional monies that the governor was able to use from pandemic relief earlier in the year that helped him continue to fund some of his priorities that did not get into the final budget. So all in all, they made it before the July 1st deadline. So kudos for that. And now they'll start some of the heavy lifting again in the legislature on other issues come late August and early September. All right, next up is a bill that was passed separate of the budget. This we may have talked a little bit about before previously. This basically creates additional funding and extends the Wisconsin Fund, which is the Pouts Rehabilitation Program, creates staffing authority for 2 additional Pouts plan reviewers, and then also authorizes a septage study at the University of Wisconsin at Stevens Point. The septic study designed to try to figure out what is in a septic tank, and based on that, what's being land applied to fields, and then ultimately making its way into the groundwater. So valuable research that needs to be done, and hopefully will provide some auxiliary benefits for people in our industry. Okay, there were 2 decisions that were made by the Supreme Court, largely the same logic behind both of them. It was a very unusual mix of justices that created the majority. One justice did not rule on the case. And so what you have in this particular instance is, like I say, a very odd mix of all 3 of the liberal justices and one conservative justice who joined together to say that the Department of Natural Resources, which was the subject of these lawsuits or these court decisions, the question was whether or not the Department of Natural Resources has the authority to create rules and regulations that are not specifically called out by the legislature. So in particular, these cases deal with farming practices up in the Kewaunee County area, and also the use of high capacity wells that affected the Lake Beulah area near East Troy, and the cumulative effect of multiple wells in an area. So what we have really is a Supreme Court that decided by a narrow majority, but a majority nonetheless, that says that when the legislature agreed that the Department of Natural Resources could be created, and that one of its responsibilities was to look at the public trust doctrine and support that, um, what the legislature did was delegate its authority that's provided in the Constitution under the public trust doctrine to say, protect the state's surface water. So if you protect the surface water and there's some interaction between the groundwater and the surface water, it gives the agency a wide swath to regulate. And again, because the authority is born out of the Constitution, and then the legislature delegated it when it created the DNR, there was at least one conservative on the court that said that's enough, that they have the authority to do additional regulation that isn't specifically called for by the legislature, because their larger charge as a state agency allows them to do that. So this case will continue back and forth. I'm sure it has moved over the course of now probably almost a decade on both of these cases, but as of today, the DNR can consider cumulative impact and consider agricultural loads in particular communities and their effects on surface and groundwaters, and then regulate accordingly. So we'll see what comes of that in the weeks and months ahead. Again, any legislation will be very difficult to pass because of the split between the legislature and the governor's office. So it means the DNR will have this authority and a Supreme Court decision to back it, at least for the foreseeable future. Okay, another one of the things that we are looking at is a bill draft that was introduced, is circulated anyways, by a legislator out of the Green Bay area. It's what's called an energy passive recharge product. And in this particular case, it is think of it as something of an injection well, but the idea is to take surface waters and to drill through the upper levels in order to allow the water to pass more quickly into levels below. So in certain areas where you'll get a lot of pooling of surface waters, this would allow those to get down into the ground faster and then create recharge for the aquifers below. We don't know a whole lot about what the intention is. That's a meeting that we're in the process of setting up, but we want to learn more about this. Currently, the regulations don't allow for injection wells in the state, so that's the reason why this requires legislation to be passed. So still in the learning process on this one, more as we get that. Okay. Some of you may have received notifications from Wood County that they would begin to manage the well program in the county on their own. And what that is basically is there's authority that's given in the state statutes and then in the rules that allows counties to take on the responsibility for administering certain programs. And among those is the well inspection programs. Now, there's currently between a dozen, maybe as many as 14 counties that are already doing this. Some of you are probably working in those counties as well. So the question that was asked of us when drillers were getting this is, can they do that? And the answer is yes. The next question was, well, why would they do that? And probably the main reason is to create more control in their own area for what's happening with well construction and also with well inspections. Now, what I mean by that isn't to suggest that counties can have their own codes. They're required to pass a statute. The statute essentially says that they're going to conform with NRA 12. So there really is uniformity still. The real question that comes into play then is, are they able to inspect all of the wells in a community? Are they able to go out and seek and find and ask that abandoned wells be sealed and filled and such? So what you really have is communities and counties saying, if we do this through the DNR, we are reliant upon the DNR resources that they may have available. If we want to do something more with the program and create a higher standard, not a higher standard in the way of a different code, but a higher standard in terms of 100% enforcement, for instance, or inspection of wells, as opposed to 10%, 20%, or whatever the DNR might be able to provide. That's the reason the counties are doing this. When they do it, they'll create an inspector and they will have to fund that position, which is why there's redundancy on some of the fees that are being paid, some of the paperwork that's being filed. So the state paperwork still gets filed, the county paperwork also gets filed. So there's some redundancy there for the drillers and such. And we're looking into a little bit more of that and having some conversations with the people of Wood County to understand what other motivations they might have had and such as well. What I would point out here is that if you're aware of, and first I'd suggest that you stay in contact with county government on any number of issues that might affect your business, zoning issues and such. So keep an eye on what's going on there. But because it's very difficult to see everything that's going on in all 72 counties, we rely a little bit on you as an early warning system for when these kinds of things may be moving through a county committee process and up to a county board. If you're aware of anything like this happening in your county, we would rather address it affirmatively before it passes than to kind of come back and say, hey, county board, we think you were in error here. We can do that and we'll do it as appropriate, but it's a lot easier to catch these things on the front end and have a discussion as to why it may not be a good idea or maybe a good idea depending upon the issue. But we need to rely on all of you to be our radar out there and keep us informed of anything that's happening in your area. If you see something, give us a call, let us know, and we'll see what assistance we can be. But in the meantime, just be aware that Wood County has sent out letters to drillers. It spells out more of the information. All of this is online at the Wood County site as well. And again, it's a continuing and ongoing issue that we are looking into right now, but just so you're aware of what has happened. Well, that is our report for the month. Again, my name is Jeff Byriger, and you'll see it there on the screen. You'll also see my email address if you'd like to reach out to me with any issues. And that's my cell phone number. You are free to contact me by cell as well. Happy to talk about these issues or anything else that might be on your mind. As always, thank you for being a member of the Wisconsin Water Well Association. We appreciate everything that you're doing out there, very, very much helping to keep our state safe from an environmental standpoint and providing clean drinking water for the many, many people who are relying on public and private wells across the state. So with that, I'm going to end this month's report. Thanks again, and we'll talk to you in about a month.